Committee on Oversight and Government Reform will come to order pursuant to Committee Rule 5B and House Rule 11-2H4. The Chair announces that he may postpone further proceedings today on any question of approving any measure or matter or adopting an amendment on which a recorded vote of the yeas and nays are ordered. And without objection, the Chair is authorized to declare a recess at any time. Today we're in markup. We have a number of bills we have been working on, and our first item for consideration is H.R. 4359. The Administrative Leave Reform Act. I'd appreciate it if the clerk would designate the bill.
H.R. 4359 to amend Title V United States Code to provide that federal employees may not be placed on administrative leave for more than 14 days during any year for misconduct or poor performance and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Without objection, so ordered. I now recognize myself for 5 minutes for a statement on this bill. We had started this bill, and then I pulled it from the previous markup so we could work in a bipartisan way to come to a plausible solution, and I think we've been able to accomplish that here today. We, as the committee, have heard a number of cases in which federal employees have committed some form of misconduct. And let me be clear. The overwhelming majority, I've said this many times, the overwhelming majority of employees are good, honest, decent, hardworking people. They care for their country, and they do a good job. But there are these bad apples that every once in a while need to be dealt with. Administrative leave is an appropriate tool to a point. And it's not fair to the employee, nor is it fair to the government or the coworkers to allow these people in perpetuity to continue to be out there without a resolution of whatever their case is. Oftentimes, the employee was right. Sometimes the employee is wrong. It's not a reflection of guilt or innocence, but it is a reflection that there is a process to go through. This Administrative Leave Reform Act caps the use of administrative leave at 14 days per calendar year for cases related to misconduct or performance. This reform is to prevent individuals from remaining on administrative leave in perpetuity, allowing them to receive pay while not doing work. I refer to a GAO report from October of 2014. They looked at the years of 2011 through 2013. What you find in that report, there were some 4,000 plus people who were on administrative leave longer than 3 months. In fact, if you get to the longest category, what you'll see is that there were more than 530 people that were on administrative leave somewhere between 9 months and 3 years. Perhaps there's a good, decent reason why somebody would remain there for years, but what we're asking for and moving towards is some sort of reporting mechanism and a trigger that I would hope would accelerate the process. That's what we're trying to address here. One of the concerns that I have, again in the context of the broader group, is that this administrative leave is perhaps being misused and even abused. For example, the Inspector General for the EPA found that the EPA's use of administrative leave was disproportionate compared to OPM's guidance to use unacceptable performance and misconduct. In one instance, an employee confessed to, quote, knowingly and intentionally engaging in sexual conduct with a child younger than 17 years, end quote. This happened in the 1990s. After the employee was arrested on a probation violation, that individual was put on administrative leave in August of 2013. He accrued 300 hours of paid leave before being removed from the agency. Further, that employee was rehired from September 2014 through January 2015 with no documentation in the employee's disciplinary action file. We let a predator back in the door. Another EPA Inspector General report found an employee earning $120,000 annually who was watching pornography on the job. This was not just an accidental, whoops, I saw this. This was a very egregious case of repetitive, unacceptable behavior. That employee was placed on administrative leave for more than a year before they were fired. Why should the taxpayers have to fund this pervert for more than a year. It just shouldn't happen. According to a GAO report on the use of administrative leave, as I said, I went through those stats. We're talking about a large number of employees. In the context of the 2 million federal employees, I recognize it's a small percentage, but we have a duty and obligation to take care of it. For instance, the 250 employees who are on administrative leave for more than a year cost the taxpayers in excess of $31 million. We also have to deal with some of the inquiries that are coming. Senator Grassley inquired about 58 employees DOD had on administrative leave for more than a year between 2011 and 2013. DOD didn't even respond. And again, I want to be able to address this problem. I will, in the essence of time, put my full statement into the record, but I do want to address this challenge, and I think we hopefully have come to a bipartisan understanding of how to do that. Now recognize the gentleman from Maryland, Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Chairman, we can all agree that agency overuse of administrative leave can be a problem, but the bill as it was introduced was not the solution. We need to pursue ways that agencies can use administrative leave more effectively and efficiently while preserving due process protections for federal employees. I support the substitute amendment offered by the gentleman from Massachusetts. And I want to thank you and Mr. Lynch for your hard work on this amendment. You have addressed our concerns that the underlying bill could encourage agencies to suspend an employee without pay and without due process. This amendment would preserve the ability of an agency to place employees on administrative leave in those exceptional circumstances when they may pose a threat to safety, agency mission, or government property. It would allow the agency to consider the results of a thorough and complete investigation prior to taking administrative action. It would not punish employees by stripping them of pay before an adjudication of the allegations. It would preserve the principle that a person is innocent until proven guilty. I believe that this amendment strikes the appropriate balance between the need for stricter oversight of agency use of administrative leave and employee due process rights. I urge my colleagues to join me in supporting Congressman Lynch's amendment, and with that, I yield back.
Thank the gentleman. I understand that the gentleman from Massachusetts, Mr. Lynch, will offer an amendment in the nature of the substitute. Without objection, we'll call up the amendment in the nature of the substitute and then recognize Mr. Lynch to give his statement on the ANS. The clerk will designate the amendment.
Amendment in the nature of a substitute to H.R. 4359, offered by Mr. Lynch of Massachusetts.
Let's now recognize Mr. Lynch of Massachusetts for 5 minutes to explain the amendment in the nature of the substitute. Each member should have this in their folder.
Thank you, Mr. Chairman. I want to thank you and I want to thank your staff for the way in which we've been able to work together on an acceptable substitute. This substitute amendment would improve the Administrative Leave Reform Act by adding meaningful due process protections to H.R. 4359. These protections would address the serious constitutional concerns raised by the 14-day limit on paid administrative leave established by the bill. When this legislation was first placed on the markup calendar in January, I expressed concern to the Chairman that the bill as drafted failed to include process safeguards to address the fact that certain agency investigations of employees' misconduct or poor performance may not be completed by the 14-day time limit. This bill could therefore have the unintended consequences of forcing employees whose cases are not resolved within 14 days into an indefinite unpaid leave status without any law. It's important to note that some of these employees could later be found innocent of wrongdoing. Many of them are. And to the Chairman's great credit, Mr. Chaffetz withdrew the bill from consideration, and he and his staff, as I have said, have been working with us, the ranking member, Mr. Cummings, and our staffs to incorporate due process protections into this bill. The substitute amendment reflects that bipartisan effort. The U.S. Supreme Court underscored the importance of due process for public employees in the landmark 1985 case of Cleveland Board of Education versus Loudermill. According to the Loudermill Court, while the legislature may elect not to confer a property interest in public employment, it may not constitutionally authorize the deprivation of such an interest once conferred without appropriate procedural safeguards. This is entirely consistent with the due process clause of the 14th Amendment that, of course, applies to us and the Federal Government. In line with the Loudermill case, my amendment seeks to ensure that the bill's new limitation on administrative leave, on paid administrative leave, is accompanied by constitutional protections for all Federal employees whose agencies could otherwise force them into unpaid leave with no resolution of their case after the 14-day maximum on administrative leave is reached. In particular, this amendment would require that following the 14-day administrative leave period, an employing agency must return an employee to paid duty status where the agency determines that the individual does not pose a threat to public safety, government property, or the agency mission. A return to duty could be accomplished through telework or alternative work assignments. This requirement also follows recent guidance issued by the Office of Personnel Management. In May of 2015, OPM recommended that agency policies on administrative leave related to misconduct or poor performance address, and I quote, consideration of paid duty status options such as the reassignment to alternative duties, close quote. In those limited circumstances where an employee could in fact pose a threat to him or herself, the workplace, or the agency mission, this amendment recognizes that it may be necessary for an agency to implement administrative leave beyond 14 days as a precursor to adverse action. To this end, my amendment authorizes the agencies to impose additional periods of administrative leave of no more than 30 days each in exceptional circumstances. However, an agency must report this additional leave and the circumstances that warrant it to Congress each time it is granted. If the leave was granted to await the results of an investigation, a certification by the investigating office, such as the agency's Inspector General, which often happens in this committee, or the Department of Justice, would also be required. This adds an additional level of oversight and accountability to the process. As stated by our Chairman, Mr. Chaffetz, the intention of this bill is to curb the misuse of administrative leave, paid administrative leave. And based on the prior work of the Government Accountability Office in this area, I do agree that oversight of this issue is important. However, it's equally imperative that it's equally imperative that when we undertake the responsibility of reforming Federal personnel discipline and removal procedures, we also implement corresponding due process safeguards that will serve to protect not only those employees who may be guilty of misconduct, but rather all employees in the Federal workforce. So in closing, I thank the Chairman and Ranking Member for their work on this bill. It's my understanding that we have received additional comments on this legislation from OPM and the Council of Inspector Generals on integrity and efficiency. I look forward to working with the Chairman and Ranking Member on a bipartisan basis to make additional improvements to this bill before we move to the House floor. Thank you, Mr. Chairman, and I yield back the balance of my time.
I thank the gentleman. Now recognize the gentleman from North Carolina, Mr. Meadows, for 5 minutes.
Thank you, Mr. Chairman. I just wanted to point out that this is really how the whole process should work. I can remember a markup not too many weeks ago where obviously this issue became contentious, and you as the chairman decided to pull it, work with minority staff and certainly with Mr. Lynch. And so I just wanted to go on record as saying thank you for both parties to work in a bipartisan manner to not only make this bill stronger, but obviously protect the rights of all Federal workers. And with that, I'll yield back.
I thank the gentleman, and that is the spirit in which we're doing this, and I appreciate the comments from both yourself and Mr. Lynch. We'll now recognize the gentlewoman from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you very much, Mr. Chairman, and I appreciate the way both sides have worked together. I'm not certain about Mr. Lynch's amendment. It's certainly an improvement over 14 days. But the gravamen of what is being done here, I mean, I think we all ought to understand we're all offended when somebody's able to sit at home while the government perhaps takes its sweet time in proving its accusations. What we have here is an accusation. The chairman talked about somebody who was accused of molesting a child or something. and kept on administrative leave and then hired back. I can only think that perhaps they were found not guilty. I can't believe that the government simply hired back somebody who was accused of a serious offense and then found guilty of it. The 14-day, and I'm not sure 14 to 30 days constitutionally makes much difference. The 14 days is, I think, unconstitutional on its face. Essentially, the difference between a public employer and a private employer is the due process clause of the 14th Amendment. And so, yes, you must go through a due process hearing. You must prove what you are saying. I would much have preferred to have an expedited procedure when somebody is accused and you really feel, even when it's not an emergency, an expedited procedure, because I'm not sure that the Lynch Amendment saves the constitutionality. It does improve upon it because you have to give an explanation as to why the employee is a threat to safety, the agency mission, that's very wide open, or government property. Some of this is easier to prove than others. But this constitutional right you're talking about, the other side talks about the Constitution. I think about the Constitution in its specifics. If I vote for this, it will be with great reluctance. I think anyone who, for example, is accused and the government has a serious matter to prove, and it goes on for more than 30 days, and you try to take that person and put him on leave without pay, the government will be sued immediately. And I can only hope that you have a very good defense for going from 14 days to 30 days, because I don't see a lot of difference except for the reasons that you have to lay out and a court would have before it, the reasons it would have a basis for making a judgment. And still, I think the court would wonder why the government didn't expedite its own procedure instead of putting the burden on the person who is accused. So while this is an improvement, I'm not sure it saves this particular provision from unconstitutionality. Be pleased to yield to the gentleman.
I just want to ask the sponsor of the amendment a question. It's my understanding that the 30 days, you can keep giving the 30 days leave with pay. Is that right?
Right. Okay. And look, I appreciate the gentlelady's comments, and she is spot on. Those are the same concerns that we considered when drafting this amendment. And we believe that, first of all, if you don't give due process, whether that individual is guilty or innocent, if you don't grant due process, that person gets paid. That is black letter law. So they don't even consider guilt or innocence if you have not granted due process. So that person gets paid if you violate the due process clause of the 14th Amendment. In this case, however, we have offered the opportunity for the government to go back and to the agency, the ability to extend that paid administrative leave while that situation is being considered. We've also carved out a situation where if there's hacking or something that we believe bringing that employee back would compromise the system or interfere with the mission of the agency, they can be held off campus, so to speak, and away from the workplace with pay, or they could telework during a certain period. So there are, or if they're a danger to the people in the workplace, they can be kept off that campus. They don't have to be brought back on. So we think that there are sufficient safeguards to meet the due process requirements of the 14th Amendment in this rework of the bill. So,
Could I ask the gentleman a
Sure.
quick question?
Reclaiming my time and yield back.
I'm sorry.
The 30 days, one can come back to who and get an additional 30 days, and is it one additional 30 days? The accusation may be serious enough that if you're going to give due process and do an investigation where you may in fact find somebody guilty, it may require time. Is a limitation on the number of times you can come back offering an explanation for why you need more time?
Well, The requirement is that they state the case for why the extension is necessary and that they inform Congress as to any time that extension of time is granted, so that we don't find out, as the Chairman has noted in several cases, years later, that this person is still on the payroll, still being paid, even though, they were found at fault.
So they come back to this committee, and who do they?
To this committee. If the gentlewoman will yield, the spirit in which we're doing this is that it's not fair to the employee. It's also not unfair. It's not fair to the government to have this go on in perpetuity. If there is a legitimate ongoing investigation, sometimes that takes a long time. Sometimes it takes a month. There is room under this bill and this amendment to make that sort of adjustment. All we're asking for is a report. What I hear and see and what we need to address is when the investigation's completed, but then they continue on paid administrative leave sometimes, and there are some cases that go on for years. And again, that's not the majority of them, but we're trying to address this small problem. We saw it in a GAO report. We saw it in recommendations from the Office of Personnel Management. We're trying to responsibly address that. I look forward to working with the gentlewoman as hopefully we can pass this and that as we go to the floor to clarify any of those concerns. But we're not trying to do anything to limit somebody's right as an employee to have it fully adjudicated, but also in a speedy process and addressed so that they can get on with some certainty in their lives. That's the spirit in which we're doing this.
Well, with that kind of flexibility, I think, Mr. Chairman, so that one takes into account the fact that you may have a serious accusation, you may want the government to be able to prove it. Therefore, you want to give the government the time to prove it. And of course, under our constitutional system, that means that the employee gets to stay longer than we would have desired. So I think with that kind of flexibility, we may be in better shape.
Does any other member wish to be heard on this amendment? Gentleman from Virginia, Mr. Conley, is now recognized for 5 minutes.
Thank you, Mr. Chairman. And I want to thank you and the ranking member for working with Mr. Lynch to make what would have been a very difficult bill to support much improved. And I really appreciate the spirit in which you approach this. I think that's how this committee ought to operate, as my friend Mr. Meadows said. This is a difficult one because we're trying to balance protecting the rights of federal employees, which are constitutionally protected, as Mr. Lynch indicated, with the need for genuine accountability. As you said, Mr. Chairman, some of these cases go on for years unadjudicated. And that's not fair to the individual, and it's not fair to the taxpayer or fellow employees when a cloud is allowed to hang over somebody's head indefinitely. And so if we can improve the accountability while protecting rights, and I think the Lynch revision does that, I think that's an improvement of the existing system. And as you indicated, Mr. Chairman, and I appreciate that too, we have some time between now and when this bill comes to the floor, that if further refinements are necessary to clarify those protections, let's take advantage of that time and work together to make those improvements. Finally, on a personal note, Mr. Chairman, I'm going to have to leave this markup to go to a funeral. Officer Gwendon in Prince William County, Virginia, was killed this week by a gunman who also killed his wife in a domestic violence dispute. It was Officer Gwendon's first day on the job. She was 90 minutes into her first shift. So my community mourns, and I know my colleagues will understand my necessary absence. Thank you.
No, I thank the gentleman, and I appreciate the heartfelt sadness and concern, and no, that is, it's just so sad in every aspect, and we thank the men and women who serve, and that phone rings and the call comes in, they don't know what they're getting themselves into. So duly noted and appreciated, and I thank the gentleman for his comments. Does any other member wish to speak on the amendment and the nature of the substitute? Are there any amendments to the amendment in the nature of the substitute? If not, the question is now on the amendment in the nature of a substitute offered by the gentleman from Massachusetts, Mr. Lynch. Those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it. The amendment is agreed to. The question is now on the adoption and favorably reporting H.R. 4. Are there any other members who wish to speak on this bill? The question is now on the adoption and favorably reporting H.R. 4359 as amended to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. Our next item for consideration is H.R. 4639, the Thoroughly Investigating Retaliation Against Whistleblowers Act. The clerk will designate the bill.
H.R. 4639, to reauthorize the Office of Special Counsel to amend Title V United States Code to provide modifications to authorities relating to the Office of Special Counsel and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Without objection, so ordered. I now recognize the sponsor of the bill, the gentleman from Iowa, Mr. Blum, for 5 minutes to explain the legislation.
Thank you, Mr. Chairman. I am pleased to introduce this legislation to reauthorize the Office of Special Counsel for an additional 5-year period to protect whistleblowers, federal employees who have the courage to come forward to expose waste, fraud, and abuse in the federal government and who are so vitally important to the work here of the Oversight Committee. The Office of Special Counsel performs a variety of important responsibilities. The main one is preventing retaliation against whistleblowers from executive branch agencies. Once again, this is vitally important to the work we perform here in this committee. I am proud of the support of this bipartisan bill has received from the whistleblower community and from those who care deeply about this committee's efforts to perform effective oversight in our federal government. Since the last authorization expired in 2007, there are a number of necessary reforms for special counsel as the role of the office continues to grow and evolve. By enacting this legislation, we can ensure the Office of Special Counsel will have the access to federal agency records that are absolutely necessary to perform their duty of protecting federal employees who have had the courage to speak up about malpractice, mismanagement, and fraud in our federal government. I think we can all agree how unfortunate it is that some of our executive agencies continue to stonewall the Office of Special Counsel in order to prevent them from investigating retaliatory actions against whistleblowers, even going so far as to invoke executive privilege when dealing with the OSC. Common sense tells us this is an unacceptable behavior. If the Office of Special Counsel isn't granted the access to the information it needs, there's no way it can properly conduct the duties authorized by Congress. This bill also takes important steps to increase the efficiency and the effectiveness of the Office of Special Counsel, such as allowing OSC to use a simplified process to reduce duplicative complaints to better focus their limited resource on allegations and investigations, and instituting a common-sense 3-year statute of limitations, after which document recovery and witness recollections can be difficult to obtain. Mr. Chairman, before concluding my remarks, I'd like to specifically highlight the important work of the Office of Special Counsel performed recently in their exposure of the mismanagement and abuse of our sick veterans at the Department of Veterans Affairs. That incident serves as a great reminder of the service the OSC provides in exposing and correcting problems within the federal government. I would also like to note the excellent work of the current Special Counsel, Carolyn Lerner, who is a welcome breath of fresh air in this role. Mr. Chairman, the Office of Special Counsel has an important role to play in protecting the whistleblowers who play a critical role in rooting out waste, fraud, and abuse in our federal government. This legislation will enable them to continue performing their duties on behalf of all American taxpayers, and I urge my colleagues on both sides of the aisle to support this legislation. Thank you, Mr. Chairman, and I yield back the balance of my time.
I thank the gentleman. We'll now recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. I strongly support the Office of Special Counsel Reauthorization Act of 2016. And I want to thank you, Mr. Chairman, for working with me and my staff in a bipartisan manner to develop this bill. The Office of Special Counsel serves a critical role for the federal government. OSC protects federal employees, especially whistleblowers, from prohibited personnel practices. OSC also serves as a safe place for federal whistleblowers to disclose wrongdoing. The statutory authorization for this agency ended in fiscal year 2007, and the reauthorization is long overdue. This bill would reauthorize OSC through fiscal year 2020. The current special counsel, Carolyn Lerner, has done a superb job of leading OSC to being an effective and efficient investigative body. This bill would make changes that will help OSC conduct investigations and to hold agencies accountable when wrongdoing is identified. For example, the bill would provide OSC with statutory authority to obtain information from agencies during an investigation. We saw one of the most egregious examples of agency resistance when the former chairman of the Chemical Safety Board refused to even provide a privileged log to OSC during an investigation of retaliation against an employee. Providing statutory authority to OSC would send a message to agencies that they must cooperate in the same way Congress expects agencies to cooperate with inspectors general and GAO. This bill would also increase accountability for agencies when allegations of misconduct are sustained. Agencies that fail to implement a recommendation made by OSC would be required to explain why they failed to take such actions. Mr. Chairman, this is a good bill, and I look forward to working with you and other members of the committee to make sure it is enacted before the end of Congress, and with that, I yield back.
I thank the gentleman. Do any other members wish to speak on the bill? Gentleman from North Carolina.
Mr. Chairman, I have an amendment at the desk.
Oh,
I'll yield back.
sorry, but let me recognize the gentleman from Massachusetts first, and then we will. Gentleman is recognized for 5 minutes. Mr. Lynch.
Thank you, Mr. Chairman. I have one question on this. At page 5 of the bill, actually it starts at page 5 of the bill. We talk about, in this bill, it talks about termination of Office of Special Counsel Investigations. And it states that one of the grounds for terminating an investigation would be if the whistleblower knew or should have known of the prohibited personnel practice more than 3 years prior, then that is grounds for the OSC terminating the investigation. I just want to point out that that's a limitation on investigations themselves. And I could give you some stunning and relevant examples of practices that have gone on for more than 3 years within government that we find outrageous on both sides of the aisle, but have been in practice for more than 3 years. So by having this 3-year statute of limitations, in other words, if something's been going on for more than 3 years and nobody has complained about it, if they should have known about it, that practice is beyond the reach of the Office of Special Counsel under the text of this bill. I just want to raise that issue. And look, I'm concerned about that. I think otherwise it is a very sound bill, and I fully support it. But I wouldn't want to cut off our ability or the special counsel's ability to go back and investigate a prohibited practice just because it's been going on for more than 3 years. It basically creates a statute of limitation for wrongful conduct. And I don't know if the sponsor would accept a friendly amendment, or we could work it out. I don't want to go through a whole formal amendment process, but maybe we could just revisit that one section and improve the bill. That's all. I yield back.
I thank the gentleman. Let us digest that, and as we do that, let's now recognize the gentleman from North Carolina, who I believe has an amendment.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will designate the amendment.
Amendment to H.R. 4639, offered by Mr. Meadows of North Carolina. At the end of the bill, add the following: Section 9, Regulations.
Gentleman from North Carolina, Mr. Meadows, is recognized for 5 minutes to explain his amendment. Without objection, the amendment is considered as read.
Thank you, Mr. Chairman. This amendment would require the office's special counsel to adopt regulations surrounding its prohibited personnel practice investigations and its whistleblower disclosure program. Interestingly enough, this is one of the few agencies in the federal government that does not have regulations implementing their main statutory responsibilities. It's been some 37 years, and the OSC has never had any such functional rules. And so in developing them, I think it's something that the whistleblower community has long supported. We can certainly hope that any future special counsels will bring as much experience and zeal to the job as Carolyn Lerner has. But if not, and if that is not the case, certainly implementing these regulations over the next 2 years would give relevance at OSC and really give some kind of degree of certainty going forward. And so by adopting this particular amendment, it would actually be giving some more structure and implementation to the great work that you and Mr. Blum has taken on as a result of this particular piece of legislation. And with that, I would strongly urge my colleagues to support the amendment. I yield back.
I thank the gentleman. I would now recognize myself for 5 minutes. Proud of the fact that the committee is addressing this problem. It should be, these types of things should be reauthorized. I appreciate the amendment that the gentleman from North Carolina is offering. I think we've worked in a good bipartisan way to come to a something that would be acceptable. I do find that Ms. Lerner has been a breath of fresh air. She in particular has been very helpful and willing to come and testify before the committee. So many of these things are wrapped around the attitude of the person who is in charge, and certainly we have a good person who cares deeply about that. Nevertheless, it is time to refresh this piece of legislation. I would like to address the situation that Mr. Lynch of Massachusetts brought up, and hope that we have had an opportunity to resolve that. The understanding of that paragraph, and this is why we do these markups, is a good thing to think these through and talk these through. It's, under my understanding, an option that allows the special counsel to accelerate the process if need be. Otherwise, it's exhaustive in terms of trying to close these things out. It doesn't force them to do that, but does give them the option and the latitude to do that. And I don't know if the gentleman from Massachusetts would be happy to yield to him.
Thank you, Mr. Chairman. And I think we've just had a discussion offline. I think if it is clear that what I did not want to happen is to have a presumption that some conduct, over 3 years old, even though it's wrongful conduct, would be beyond the investigation of the OSC. So I just ask that we amplify the language a little bit and say it's at the Office of Special Counsel's discretion, so that some other party, the executive or us, wouldn't be able to squeeze the Office of Special Counsel and say, hey, that's over 3 years old, you need to drop it. So as long as it's internally at the discretion of the Office of Special Counsel, I think that's fine. And I think we can work that out without any major amendment. It's really a technical change. So I thank the Chairman for his indulgence.
Listen, I want to be on the record as concurring with the concern and the comments that you have, and we will work together, assuming this bill goes forward, to go to the floor. That is the intention and the spirit in which we're doing it. And if there needs to be a clarifying word or two, we'll figure that out, but that is the intention. So with that, I will yield back. Are there any other members who wish to speak on the amendment offered by Mr. Meadows of North Carolina? Are there any, is there any further discussion on the amendment? Are there any amendments to the amendment? If not, the question is now on the amendment offered by the gentleman from North Carolina, Mr. Meadows. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it. The amendment is agreed to. Are there any further amendments to the bill? If none, the question is now on the adoption and favorably reporting H.R. 4639 as amended to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the Chair, the ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. Our next item for consideration is H.R. 4392, to amend Title V of the United States Code to require that the Office of Personnel Management submit an annual report to Congress relating to the use of official time by Federal employees. The clerk will designate the bill.
H.R. 4392, to amend Title V United States Code to require that the Office of Personnel Management submit an annual report to Congress relating to the use of official time by Federal employees.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Without objection, so ordered. I understand that the gentleman from Georgia, Mr. Heiss, will offer an amendment in the nature of the substitute to the bill. Without objection, we'll call up the amendment in the nature of a substitute and then recognize Mr. Heiss to give one statement on both the amendment in the nature of the substitute and the underlying bill. The clerk will designate the amendment.
Amendment in the nature of a substitute to H.R. 4392, offered by Mr. Heiss of Georgia. Strike all after the enacting clause and insert the following. Section 1, reporting requirement.
Now I'd like to recognize Mr. Heiss of Georgia for 5 minutes to explain the legislation and the amendment in the nature of a substitute.
Thank you very much, Mr. Chairman. And I also would like to thank my colleague, Congressman Ross of Florida, for introducing this legislation. I think we talk a lot about the need for accountability, and to me this is a bill that addresses that issue tremendously. In fact, I myself last year introduced a bill also trying to address official time. This is an extremely important issue. Basically, official time is when Federal employees stop doing the assigned work of their agency and instead perform tasks for labor unions. And shockingly, there's no requirements to report information on official time to the taxpayer. Although OPM does provide some reporting, OPM's current process results simply in incomplete and untimely reports. As an example from this committee, it took months and it took a lot of pressure from this committee before the administration released official time data for FY 2011 back in February of 2013. And in fact, the most recent report that we have from OPM was issued in October of 2014, but that only provided information regarding official time from 2012. So we're years behind in getting updated reporting information. In fact, the 2012 information that we do have, which of course is the most recent, it revealed that unions at 62 different agencies represented more than 1.2 million non-postal Federal employees, which is an increase of 1.65% from that in 2011. That report also shows that Federal employees spent 3.4 million total official time hours during 2012. I mean, that's an amazing amount of time, 3.4 million man-hours. That also is an increase of 1.3% from the prior year. Most alarmingly, to me, the Federal government charged the taxpayers $157 million for the official time hours in salaries and benefits in 2012. Unfortunately, the most recent report data is now nearly 3.5 years old. Who knows what has happened in the last 3.5 years? So to address this problem, Representative Dennis Ross has introduced this simple bill designed to ensure Congress receives specific and timely information on official time usage. Specifically, H.R. 4392 requires OPM to report a detailed report on official time usage by Federal employees. They must report the total amount of official time granted and the specific activities for which official time was used. OPM must additionally report the number of employees that are using 100% of official time to do nothing but union business. The amendment that I am offering requires OPM to also include in the annual report a description of any room or space designated at the agency where official time activities will be conducted, including square footage of any such room or space. In response to a letter sent from this committee to agencies requesting information on space designated for conducting official time, the Consumer Financial Protection Bureau was able to promptly respond, and they reported that the agency has one room, approximately 70 square feet, that is designated for official time activities. So obviously, according from the response from the CFPB, this is not a burdensome requirement to our agencies. The continued and timely release of official time information is absolutely necessary for this committee and the American taxpayers to assess the extent to which such time contributes to the productivity and effectiveness of the federal government. And with that, Mr. Chairman, I urge my colleagues to join me in supporting this important measure. Thank you.
Thank the gentleman. We'll now recognize the ranking member, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. H.R. 4392, as introduced, is identical to legislation that was reported out of this committee last Congress. I appreciated that the majority worked with us last Congress to eliminate provisions in the prior bill that would have been burdensome for agencies to comply with. The legislation would require the Office of Personnel Management to submit an annual report to Congress on the use of, quote, official time. Federal employees who are union representatives use official time to represent employees in grievances, participate in labor management meetings, and negotiate collective bargaining agreements. OPM has been voluntarily issuing reports on official time since 2002. This legislation would help ensure that OPM issue the reports at the same time every year. In addition, federal agencies would be required to submit data for the official time reports to OPM by the end of each calendar year. We expect that this language will help OPM collect the data more easily and in a more timely manner from federal agencies. Unfortunately, the amendment offered by Representative Heiss that is now under consideration adds back into the bill reporting requirements on certain information removed during the last Congress that may be very difficult for some agencies to collect. Some of that information has not been requested by the majority in letters sent, has also been requested by the majority in letters sent to most of the larger federal agencies. I would ask that as this bill moves forward, the committee consider further modifications to the requirements of the bill based on the agency's responses to those letters. And with that, I yield back.
Thank the gentleman. Does any other member wish to speak on the amendment or the bill? Gentleman from Massachusetts, Mr. Lynch, is now recognized.
Thank you, Mr. Chairman. I'd just like to note that the extensive number of hearings and floor amendments and standalone bills that have targeted official time over the past several years seem to indicate that a few of my colleagues may have a fundamental misunderstanding of what precisely official time is. So let me just note that the use of official time by federal employees is a statutory right, and it is designed to promote agency cost savings, productivity, and workplace safety. Under the Civil Service Reform Act of 1978, federal employees represented by a union may be granted official time to perform certain activities during work hours that serve the joint interests of both labor and management. In addition, federal law provides that the amount of time that may be used is limited to that which labor and management agree is reasonable, that they agree is necessary, and that they agree is in the public interest. While federal employees may request official time, federal managers and supervisors retain exclusive authority over whether to approve official time requests. Accordingly, official time activities that are permissible include employee participation in labor management meetings that seek to identify ways to improve agency efficiencies, workplace safety, and employee training. Moreover, federal employees on official time may also work to enforce employee protections against unfair employment discrimination. Federal employees have recently used official time to participate in health and safety programs operated by the Occupational Health and Safety Administration. They've also used official time to work with the Department of Defense on development of a department-wide system to improve employee evaluation and hiring practices. Federal employees have also used official time to examine potential employee grievances, unfair labor practices, and equal employment opportunity cases to determine those issues that could be resolved without litigation, and therefore saving these agencies and the taxpayer enormous amounts of money. I'll conclude by saying what official time is not. Under Federal law, official time may not be used to solicit union membership. It may not be used to conduct union meetings or elections, and it may not be used to conduct any partisan political activities. So I really think that this bill is a solution in search of a problem. I want to thank you, Mr. Chairman, and I yield the balance of my time.
I thank the gentleman. Will now recognize Ms. Lawrence for 5 minutes.
Thank you, Mr. Chairman. I just wanted to continue on the enlightenment that my colleague, Mr. Lynch, has provided. Often we sit in Congress and we perceive a problem, and then we increase the workload of our departments that we have oversight over. It's kind of questioning to me about the space allocation. Having served in HR and dealt with labor organizations and labor activity within our federal agencies, often there is not a room that is designated for labor work. There is often in facilities where a manager will just vacate a room to allow the union representative to talk to an employee. So here we are again, composing language to send to our agencies, asking for this report to be submitted to whom, and who is, you know, there is this annual process that happens where they'll say, we've been sending this report for the last 5 years. Has anyone even looked at it? What are they doing with it? And I always question, before we send it, what would we achieve by knowing the actual location and place where union activity is happening? And if we get this information, which Mr. Lynch has so eloquently described as the right of our federal employees, this is not something, if this was something being done that is not supported by regulation, rules, or policy, absolutely. Let's find out so we can correct it. It is clearly not a waste of our taxpayers' dollars when employees are using their rights. And I always like to highlight that the one thing that we can never push back when it comes to labor, unions, and our workers is the safety issue. And labor management meetings have happened throughout our federal agencies that have actually improved processes and efficiencies that we should applaud. And if any federal employee is not being given their rights that they have as a federal employee, they should have someone to go to. So I just wanted to echo Mr. Lynch's clear definition of why we have this official time, and to question why we would ever need to know where physically in that building we're holding the meeting. And that goes to Mr. Cummings, who have said that if we have talked about this and recognized in previous years that some of the requirements or things we're asking for, it's just really adding more work to our administration without any direct benefit, that we will continue that conversation and not proceed with legislation just to create paperwork reports that has no immediate, unless my colleague can explain, value. Thank you so much.
Thank you. I'll now recognize myself for 5 minutes. And before I yield, let me just say, I would hope there'd be some respect that some members do want to see this information. It's really a sunshine bill. I agree with probably most of what Mr. Lynch and you said, the gentlewoman from Michigan said. But there are those of us that I don't know, we don't know. And so it does get sent to Congress. It will be something that I think is fairly easy to put together. I don't think it's overly burdensome. And the Consumer Financial Protection Bureau got it to us pretty quick. It's not overly burdensome, I don't think. And there are those of us that would like to know and see that information in terms of time. And it doesn't specify where in the building. It's just a question of how much space. It struck me with the Consumer Financial Protection Bureau, which is bigger than the Securities and Exchange Commission, 70 square feet. That's like barely a closet. So, you know, it was like surprising. I didn't know. And we won't know unless we ask the question, and that's why we're moving forward with this. The gentleman from Georgia, Mr. Heiss, is now yield to the gentleman from Georgia, Mr. Heiss, for
Thank you, Mr. Chairman, and I agree. This is whether it's a whole nother question about the right, I suppose, of official time, and as Mr. Lynch said, that's a right. But I think this is all about accountability, and I think at the end of the day, the taxpayers also have a right to know how official time is being used. And at the present time, we have extremely poor reporting, and this is not an overburdensome issue, but it does allow us as members of Congress to know what's going on with official time. And if there are issues to address, we can address those. But at this point, accountability is a good thing, and that's all this is trying to accomplish. That I yield back. Thank you.
the gentleman yields back, and I'll yield back as well. Does any other member wish to speak on the amendment in the nature of the substitute? Are there any amendments to the amendment in the nature of the substitute? If none, the question is now on the amendment in the nature of a substitute offered by the gentleman from Georgia, Mr. Heiss. Those in favor signify by saying aye. Aye. Those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it, and the amendment is agreed to. The question is now on adoption and favorably reporting H.R. 4392 as amended to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no. No. In the opinion of the chair, the ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. Our next item under consideration is H.R. 4612, the Midnight Rule Relief Act of 2016. The clerk will designate the bill.
H.R. 4612, to ensure economic stability, accountability, and efficiency of federal government operations by establishing a moratorium on midnight rules during a president's final days in office and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Without objection, so ordered. I now recognize the sponsor of the bill, the gentleman from Michigan, Mr. Walberg, for 5 minutes to explain the legislation.
Thank you, Mr. Chairman. Outgoing presidents have a clear incentive to work to shore up their legacy and finish priority lists during their last few months in office. That's expected. That's normal. This incentive grows even stronger, though, in the period between the election and the inauguration of a new president, as there will be little to no negative consequences or opportunities for constructive feedback to keep the administration from making politically motivated regulatory decisions. However, the negative consequences will simply fall on everyone else who will have to deal with the new rules and their damage, potentially, to the economy. This Washington ritual has become so common that it even has its own name, midnight rules. Research has shown that an average of 17% more rules were promulgated between Election Day and Inauguration Day compared to non-election years. This trend in midnight rulemaking has been even more dramatic in recent years, with the highest spikes occurring in 1980, 1992, and 2000. To help put this in perspective, the outgoing Clinton administration published 51% more pages of rules than it did during the average of the same period of the prior 3 years. In one of these midnight rules, the Clinton administration published a proposed rule on residential clothes washers mandating stores to sell government-approved washing machines considered to be, quote, more efficient. Just 3 months later, and 8 days before the end of his term, the final rule with far-reaching effects for household appliances was published. The rulemaking process for this major rule took less time than the comment period for the Clean Power Plan. And though there were several reports that found the rule would increase cost on consumers, it was quickly finalized. To halt the practice of midnight rules, a practice misused by presidents of both parties, I introduced H.R. 4612, the Midnight Rule Relief Act. This legislation would establish a 10-week regulatory moratorium on major rules between Election Day and the inauguration of a new president. So far, since 2009, the current administration is already responsible for over $600 billion in regulatory costs from major rules. And given the administration's tendency to overregulate and overreach, all indications are they are not done. In the Department of Energy alone, potentially 6 remaining regulations could have an annual cost of $2.9 billion. Placing a moratorium on midnight regulations is a concept that has been raised by both Republicans and Democrats. In fact, in 2008, Congressman Nadler introduced a very similar bill to curb midnight rules under the outgoing Bush administration. I hope we can work together to ensure small businesses in Michigan, my state, and across the country aren't faced with a new onslaught of excessive regulations that stifle wages, job creation, and economic growth. With that, I urge my colleagues to support this legislation, and I reserve.
The gentleman yields back.
Mr. Chairman, I guess I yield back.
Okay. Thank you, gentlemen. We now recognize the ranking member, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. I oppose this bill. This bill would block the Obama administration and future administrations from proposing or finalizing significant rules during its last months. The Senate Republicans are saying they will refuse to even hold a hearing on President Obama's Supreme Court nominee. And now House Republicans want to block the administration from even issuing rules during its last 4 months. The President is the President until January 2017. I agree that at the end of an administration, there is likely to be an increase in regulations. We saw it both in the Clinton and Bush administrations. I also agree that if an agency were to take shortcuts and not allow the proper procedures, that could raise legitimate concerns. However, there is no evidence that this administration plans to take shortcuts. In fact, just the opposite is true. On December 17, 2015, the Administrator of the Office of Information and Regulatory Affairs, Howard Shalansky, sent a memo urging agencies to complete rulemaking early. The memo said, and I quote, "Agencies should strive to complete their highest priority rulemakings by the summer of 2016 to avoid an end-of-year scramble that has the potential to lower the quality of regulations that OIRA receives for review and to use the resources available for interagency review." End of quote. Susan Dudley, who served as OIRA's administrator under President George W. Bush, lauded Administrator Shalansky's memo and noted that it was issued much earlier than similar memos during the Bush administration. In a February 23, 2016 article for Forbes, Ms. Dudley said, and I quote, That gives agencies more than a year's notice of the administration's intent to avoid a last-minute rush, in contrast to the Bolton memo, which was issued less than 9 months before President Bush's final day in office." End of quote. As I've said many times in this committee, regulations do play a critical role in protecting the health and safety of the constituents we represent. Blocking agencies from finalizing rules that have been under consideration for years just because it's the end of the President Obama's term is not good policy. And I know, you'll say, well, this is going to apply to presidents in the future. I got that. And this is a tough time for this to come up, because I can tell you there are a lot of people who are very concerned about what's being done in the Senate to block President Obama from submitting or having a vote on a nominee, or even submitting a name. So, for example, the Department of Labor could finalize a rule this year to protect workers from exposure to silica. The silica rule was proposed, ladies and gentlemen, in 2013 and has been under consideration for nearly 20 years. Industry and other stakeholders have had ample opportunities to comment on this rule. I hope the Department of Labor finalizes the rule well before the end of the year. But if for some reason that doesn't happen, they should not be prevented from finalizing it just because it happens to be ready in November instead of March. The bill would allow for some narrow exceptions. For example, the President could exempt the rule if he determines that there is, quote, an imminent threat to health or safety or other emergency, end of quote. If a rule has been under consideration for almost 20 years, however, it is hard to believe blocking it would be considered an imminent threat. This bill also would block agencies from even proposing rules. That just does not make sense. Chairman, I ask unanimous consent to put in the record a letter the Coalition for Sensible Safeguards sent to the committee today opposing the bill.
Without objection, so ordered.
As I conclude, Mr. Chairman, here's what they said. The administration, and I quote, ends on January 20th, 2017. It is incumbent on them to do their constitutional duty to implement the laws of Congress until that date. CSSS urges members of the committee to reject both the Midnight Rule Relief Act of 2016 and false and misleading rhetoric that bears no reality to the real problems of excessive and systemic delay in the regulatory process, end quote. Mr. Chairman, I also would like to place in the record a letter from the American Association for Justice sent yesterday opposing the bill. And in that,
Without objection,
thank you,
so
Mr.
ordered.
Chairman. And there, the AAJ wrote, and I quote, and I'll close with this, Mr. Chairman. This misguided bill would jeopardize crucial public protections by blocking regulations based on timing alone. It presumes the regulations which are proposed or finalized during the so-called midnight rulemaking period are rushed and inadequately vetted. Yet many of the regulations which this moratorium would apply to have been in the regulatory process for years, end of quote. Mr. Chairman, this bill is not a good use of our time. We should respect the administration's process and the right of this administration and future administration to issue rules. And with that, I yield back, and thank you.
I thank the gentleman. I'll now recognize myself for 5 minutes. I like this bill, and I like it for several reasons. Every 4 years, I think we can take a 2.5-month timeout and allow, after the country has spoken, the change of direction of the nation. We can take those 2.5 months and allow, again, after a vote of the people, when we're changing administrations, to be able to understand and have a new direction. The country is saying we're taking a new direction. One of the things I guess I would ask rhetorically of my colleagues, here's part of the paradigm challenge. If Republicans had the White House, I'm sure Republicans would have some opposition to this bill. If the Democrats had the White House, which they do, I'm sure they would have an opposition to this bill. I don't know that the bill sponsor would be in favor of this. I want to think it more through a little bit more thoroughly, but I wonder if the enactment date should be after the swearing of the new president. We don't know who it's going to be. It's sort of like, I liken it unto, we don't change people's pay in the administration. You don't change the president's pay while he's in office. You don't change certain things while they're in office. I would like to get it done because I believe in principle it's the right thing to do. I'm not trying to go after President Obama or President whoever. I just think it is the right public policy in that time of transition to take that pause and allow a new administration to come on board and take that new direction after the people have spoken. So I think the principle of it is the right one, but I can understand the sensitivity of trying to say, hey, you're just trying to pick on my president. I think this is a problem with past presidents, and I think it's probably going to be a problem with the future presidents. And I think there are enough exceptions in the imminent health or safety risks, those types of things, that these can be dealt with.
Would the Chairman yield?
Happy to yield to the ranking.
Mr. Chairman, he is not our president. It's not your president. You said something just a moment ago to imply that he was just our president on this side. He is the President of the United States of America, been elected twice. He's the President. And one of the things that and I do appreciate what you just said, and this is a very sensitive moment for a lot of people in this country. But there's another piece to this that I think we need to keep in mind. As I said in my statement, there have been, some regulations have been worked on for years. And they may just come up to be approved at a certain point. And so while that, and I do appreciate what you said about not making it appear that we're just picking on.
Would the gentleman yield?
Sure.
On that very point, you're an attorney. Take a look at the bill. It does not stop any rule from being finalized. There is no language that stops that. So silica or anything else, it's ongoing. It can be finalized under this legislation. It doesn't stop it.
Okay. All right. Well, the fact is that, again, Mr. Chairman, with regard to, I will go back and look at it in a minute when I get finished. But again, this is, I think the President is the President until January of 2017. He earned the right to be there, and he deserves to be able to make sure that his rulemaking goes forth until the day they turn out the lights. And to be frank with you, Mr. Chairman, I think one of the things that has happened is that the American people are so frustrated with us not getting things done, and I think they're frustrated with the process. And so hopefully, I don't know what we can do with regard to resolving this, but it does concern me greatly. And again, it's a very sensitive issue for many of us. And I'll yield back.
Reclaiming my time. Part of the point is if after 7 years and 10 months it hasn't gotten done, you just wonder. And again, as the gentleman from Michigan, the sponsor of this, has indicated, those rules that are taking a long runway to get to the point where they're going to launch. That doesn't affect that. What it does affect is sort of the funny business that happens in the last little bit where you're trying to get just that little bit in. And again, I'm trying to create something and being supportive of something that is dealt with equally no matter which party affiliation. I should have clarified party affiliation. I think there is a natural tendency to try to play defense in that regard. My own personal opinion. With that, I will yield my time back and recognize the gentleman from Vermont, Mr. Welch, for 5 minutes.
Thank you, Mr. Chairman. I don't buy anything about this bill. I don't buy anything about the underlying premise of this bill. The underlying premise of this bill is that there is a body, the House of Representatives, at this moment, this committee, that can cast the Constitution aside. News alert, the President gets a 4-year term under the Constitution. Congress gets a 2-year term under the Constitution. There's a lot of regulations I hate, and I've worked with some of you on both sides of the aisle to try to thwart those. But we cannot, as a body, pretend that we have the authority to shortchange the term allowed by the Constitution, and that is exactly what's going on here.
Will the gentleman yield?
I'll yield in a minute, but I'd be glad to. We can't do that, and whether it's your party or our party, it really doesn't matter. The American people are entitled to the protections of the Constitution. And by the way, where does this start, or where does it stop, really? I mean, we're basically telling the president, you know, chill, take a vacation. You don't have to worry about nominating somebody under your constitutional responsibility to sit on the Supreme Court. You don't have to have your executive authority utilized the last couple of months. You know, why not go to Hawaii and just take it easy? Look, we don't like some rules that are proposed, but we have no authority whatsoever to interfere with, number one, the Constitution, and number two, the choice that the people of this country made as to who they wanted to be their president. We're going to have another president coming up, and some of us are going to like it and some of us aren't.
Would the gentleman yield?
I just want to make one last point, and I will. The other thing here that's really dangerous for us as an institution, this is my view, we've got collective responsibility to try to do things that are concrete, pragmatic, and move the country forward. And all of us have that goal, all of us, even though we disagree about a lot of things. But this is never going to pass. It might pass here, it might pass the House, and even who knows whether it gets through the Senate, it'll be vetoed. And what we're doing oftentimes with some of these pie-in-the-sky bills that just won't work, when we're honest with ourselves, is we're exciting people into thinking that remedies we're proposing have some meaning in their life when we know they don't. And what we're all experiencing, and it's a threat to all of us, because it's not your party or my party, it is a threat to the integrity of an institution that has to work on the part of the American people. And when we do bogus things that have no chance of working, but just excite people into thinking that they will, and we undercut the authority of the executive, we undercut our own authority and credibility, my view, we do damage to our democracy. So I don't buy what's being done here. It's not going to work. Even though I do agree a lot of regulations have to be dealt with, I also think at the end of the day, your party or mine is going to try to use whatever leverages there is. But number one, let's respect our institution. Number two, let's respect the Constitution. Reverse order. And I yield to Mr. Chaffetz.
If you wouldn't mind yielding to the gentleman from Michigan.
I thank the gentleman. And, you know, I would concur, but I reject the fact that this isn't our authority or responsibility. The Constitution, Article 1, gives us the responsibility for establishing the departments of state, establishing the agencies. Department of Labor, it is our authority to approve or disapprove what they do. It is our authority to make sure that regulations come under our purview. Yes, he is our president. He has been our president for almost 8 years. But we are the Congress representing the people, and we have the responsibility to make sure that the opportunity is given to them relative to even this, the regulatory issues. And so, no, it is in our purview. It is our responsibility. It is a responsibility to push back and to control. It is not a stepping on the President's final 10 weeks. It's doing what we should do to the end of our responsibility as well. So that's my response. I appreciate your point. But this is not a do-nothing bill or a make-work bill or a perception bill. This is how it ought to be. I yield back.
Gentleman, yield. Yeah, just one. Yeah, I want to just go back to what the gentleman sponsor said a few minutes ago. I'm looking at page 2 at top, line 2. It says, except as provided under Section 3, during the moratorium period, an agency may not propose or finalize any midnight rule. Am I missing something?
Yes.
Go ahead. No, unless it finds it. Okay.
No, I don't think you're missing anything. If I could respond to that, I don't think you're missing anything. Propose or finalize a midnight rule, but rules that have been going forward 7 years or whatever it is.
By this president, he can do it?
By this president.
No, that's not how I read it.
Gentleman's time has expired. Does any other member wish to be heard? The gentleman from Pennsylvania, Mr. Boyle, is recognized for 5 minutes.
Yeah, thank you, Mr. Chairman. I won't take the 5 minutes. I'll be brief. Very simply, put, this bill runs contrary to the Constitution. This matter was actually, if you look at, if you read the Federalist Papers, it goes into great depth about the question of whether or not our Congress and our system of government would have fixed terms or not. They came down very decidedly on the side of fixed terms. That is the case for the executive. That is also the case for the legislative branch. This bill runs contrary to that. Regardless of the president who may be in power, regardless of which party may control the White House and the executive branch, the term is until noon on January 20th, period. So I oppose this bill. I would oppose it regardless of whether or not we have a Democratic or Republican president. And I think that this is a matter that actually was decided really over 2 centuries ago. I yield back.
Gentleman yields back. Does any other member wish to be heard? Are there any amendments to the bill? Ms. Norton of the District of Columbia is recognized for her amendment.
Thank you, Mr. Chairman. I
Sorry,
have an amendment.
Go ahead. Sorry, go ahead.
I have an amendment. It doesn't go to most
The clerk will designate the amendment.
Amendment to H.R. 4612, offered by Ms. Norton of the District of Columbia, page 3, line 9, strike imminent.
So
The gentlelady from the District of Columbia is recognized for 5 minutes to explain her amendment. Without objection, the amendment is considered as read.
Thank you, Mr. Chairman. So I strike one word now. The rest of this provision is left intact. Criminal laws, national security. My amendment has to do only with health or safety, and it says or other emergency. Health, I want the word imminent struck. Mr. Chairman, there's a kind of rebellion going on in the public against, they say, Washington. Guess who that means? It's as if we want to put whoever is the president or his administration on administrative leave for an entire year. People are rebelling against what seems to be overpromising or message bills. What looks like, instead of shutting down the government, you propose measures like this. This doesn't apply after this administration. It applies to this administration. So how do you think this is going to be read in the public? If you didn't mean it to be a partisan bill, you would say at the end of the next administration, because then we would know who that would be, and it would be at least relieved of some of its partisanship. I'm asking for the kind of flexibility, Mr. Chairman, that you have just showed in time for administrative pay, where there was an accommodation made, and I think it may have saved the constitutionality of the bill. And here I'm asking only for a small change, and that's with respect to health and safety regulations. I'm not sure that any of this bill is necessary, because you should know that an administration may overturn entirely the administrative rules that have been enacted, and the courts uphold that on the theory that when there's a new administration, you have the right to look at the rules to see if they are in keeping with the last election and with empowering the president to move forward. Mr. Chairman, health and safety, it seems to me, ought to always be taken very seriously. And we're not talking about last minute, somebody proposes a rule, let's get it through here. We're talking about delay that is inherent in the administrative process. It certainly frustrates me. Until I realize that delay has a lot to do with what is required under the Constitution in the administrative process. You got to hear from all sides. Therefore, talking about extensions, then this side says, no, we have more to say. Sometimes they have hearings. They're very difficult. There are negotiated rules, for example, where you have to negotiate with both sides to get a final rule. The Administrative Conference of the United States has looked at the notion of midnight rules and says rulemaking should not be frozen during a midnight period because both rulemaking is routine and necessary to keep the government operating. It should not be shut down. So, Mr. Chairman, all I am asking is that at least with respect to health and safety, the word imminent, which is a wide open word, be erased and leave health and safety. For example, let's look at the Zika virus. Well, it might not be imminent if you live in Washington here, but if you are an American citizen living in Puerto Rico, where this morning's paper reports a virtual outbreak of the Zika virus there, that might seem imminent to you. It's a very subjective word. I'm not sure what the Flint water crisis is going to yield to other parts of the United States. I would not be surprised if its lifelong health effects didn't lead to some rules. So I don't think, even if you want to shut down rulemaking, you'd want to shut it down when health and safety is involved. And I'm asking that one word, imminent, which is a subjective word, will be perceived in many different ways, that be struck from the pending provision.
Will the gentlewoman yield?
Yield to the gentleman. I retain my time while yielding to the gentleman.
If we were to accept this amendment, would the gentlewoman support the bill?
Mr. Chairman?
I'm going to go ahead and guess. I'm going to go ahead and guess not in the essence of time.
Mr. Chair, reclaiming my time. Mr. Chairman, I'm trying to improve your bill to make it easier to pass your bill. And if this would make it easier, you should be for this amendment.
I'm not. But the second part that I mentioned earlier is a question, which is if we change the enactment date, I think we should all ask.
Would you accept my amendment and Mr. Cummings' amendment, both, for rules that have been on the agenda for more than a year?
I'm asking if the amendment.
I think we might be able to reach an accommodation with the ranking member if the combination of his amendment and my amendment, for example, were to be discussed.
We have yet to hear his amendment. I think I know what it is, but we have yet to hear that amendment. I will yield back my time. You were kind to yield to me, but nothing further. So, gentlewoman will yield back then.
Well, in the interest of hearing from the ranking member, I'll yield back. Okay. If I could hear from him before you ask.
Does any other member wish to be heard on this amendment?
Mr. Chairman.
Gentleman from Michigan is now recognized.
Well, I appreciate the concern about imminent problems, health. I think the legislation very clearly enables us to deal with those, Flint and otherwise. That's an imminent problem that could impact many other cities. I would certainly think that we have a responsibility for Puerto Rico and concerns there, and we would look that, we would take it seriously, that's a health risk, a problem we ought to deal with, and we ought to allow regulatory relief to take place. This bill allows an agency to propose or finalize a midnight rule if the President determines it's necessary due to imminent threat to health or safety, in other words, for clear emergencies. Sure, everything is subjective, but that's what we deal with. Removing the word imminent as a qualifier changes the intent entirely. It guts the bill and the intent of the bill. Instead of imminent emergencies, any agency could argue that any proposed rule could constitute some sort of threat and therefore be allowed to proceed during the moratorium. And so as a result, the amendment would effectively undo the bill by allowing virtually all rulemaking to go forward. So I must oppose this. This would truly make it, as some colleagues have said, a perception bill alone and not worth the paper it's printed on.
Would the gentleman yield?
Yes, I would.
I'm reading the language here. It says necessary because of an imminent threat to health or safety or other emergency. Suppose we just left the word emergency. At least I know what that means in a better way than the word imminent threat, which is subject. You just said that perhaps you named, I think, the Zika crisis as imminent, but it's not imminent in most parts of the country. And that is a very subjective word. You already have the word emergency in there. If you rewrote this part of the bill necessary for a threat to health or safety that is regarded as an emergency, at least I would understand what this is.
Let me, I guess, if the gentlelady would yield.
I'm glad to yield.
I would certainly, I think emergencies, we're talking about emergencies here, but if that specific word instead of imminent was something that we could work with in removing, making a little better language, I'd certainly be willing to work with you before efforts are taken on the floor of the House for a vote.
I appreciate what the gentleman is saying and would like to work to use that word rather than imminent, which is more overly broad, more wide open. Thank you very much.
I would like to oppose this amendment, but commit that before it would ever come up for a vote on the floor of the House, we'd work on that word issue that she put out dealing with emergency and find a better word or remove that word emergency.
Does the gentlewoman wish to withdraw the amendment, or does she want to?
Mr. Chairman, particularly in light of what the gentleman has said and in light of the coming amendment from the ranking member, I would withdraw the amendment.
Okay. Gentlewoman has withdrawn the amendment. And I appreciate the spirit in which we're trying to do this. So thank you both. Are there any other amendments to the bill?
Chairman, I have an amendment.
Mr. Cummings has an amendment, and the clerk will designate the amendment.
Amendment to H.R. 4612, offered by Mr. Cummings. Page 3, after line 21, insert the following new subsection.
Gentleman from Maryland is recognized for 5 minutes to explain his amendment, and without objection, the amendment is considered as read.
Mr. Chairman, my amendment would exempt from the bill rulemakings that agencies have included in their regulatory plans for a year or more. Agencies are required to submit to OMB twice a year a plan for rulemaking they plan to pursue. OMB publishes those plans twice a year as part of what is called the Unified Agenda. This amendment would still block any rule an agency tries to rush through the process. This amendment would not, however, block rules, and this is the main thing. This amendment would not block rules that have been through the proper procedures just because they happen to be finalized during the last months of the administration. This amendment allows the focus to be on true so-called midnight regulations. If those rules are truly the target of this bill, then the committee should adopt the amendment. With that, I yield back.
I thank the gentleman. We'll now recognize the gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
Thank you, Mr. Chairman. And while I respect the efforts of the ranking member on this issue, the amendment fundamentally misunderstands the purpose of this bill and would create a large loophole in the moratorium. The bill prohibits federal agencies from proposing or finalizing midnight rules during the moratorium period to allow incoming presidents to start with a clean slate. This amendment would undermine that principle by allowing outgoing presidents to simply put a marker down a year before their end of the term to be able to circumvent the moratorium entirely and move ahead with regulation on any topic during the moratorium. And may I add, it would also undermine the whole issue of public comment, review, and that ought to be a concern to us with our responsibility under Article 1 in authorizing and establishing these bureaucratic entities, these departments, these agencies, these programs. That is our responsibility. So I stand in opposition to this amendment.
Gentleman, yield.
Yes, I would.
I'm going back to the argument of a president is a president until, and this president, until January 2017. And if they have submitted a year in advance what their agenda is for rulemaking, it seems to me that that's a pretty long time to be able to get a lot of things done. And it's basically trying to make sure the very thing that you don't want, that is people rushing at the very end, trying to put rules through. So according to what you're saying, I guess even if it was 2 years out or 3 years out, at some point, the president has to be able to carry out his duties and his job. And I just think that this is a reasonable amendment. I understand your objections, but and with that, I'll yield back.
Gentleman from Michigan yields back. Any other discussion on the amendment? Gentlewoman from the District of Columbia is now recognized for 5 minutes.
Mr. Chairman, what I think the ranking member is doing is trying to take into account what I believe this amendment is after. If this amendment has any merit, it is to prevent a last-minute rush to the finish line by an administration on the theory that an administration of another party may be in power, although, again, I repeat what I said earlier, that rules may be overturned, and Supreme Court has so held. With rules that have been ongoing for a long time, what a waste of time and money it would be to halt that process, particularly when you consider that due process requires administrative agencies to take their time to hear from both sides in writing, in hearings if necessary. After that, to take into account those who oppose the rule. So if you want to speed the process, but you don't want cheating in the process, it seems to me you would not throw overboard rules that may have taken 8 or, I regret to say, even longer number of years because of the back and forth. And I admonish the committee to understand that back and forth are the operative words here, that changes are made during the rulemaking process precisely because the other side has come in with some evidence. Moreover, rulemaking occurs pursuant to bills passed by the Congress of the United States. Therefore, they're carrying out the mandate. And if you object to those rules and a new administration comes in power, there is ample flexibility on the part of both the administration and the Congress. Both may overturn those rules. Do not throw away all the time spent in the administrative process by shutting it down, particularly when many of the rules may be on the verge of implementation, when, by the way, people from the other side have despaired that it's taken so long to get a rule out. Let's keep the administration. Look, it's natural for any administration to want to wrap up what it's been doing near the end, just get it done. But as long as we're not talking about rules that are fresh, I cannot imagine why one would want to throw away the millions of dollars in time and effort that has been spent in the rulemaking process by essentially wiping out the opportunity to finalize a bill. And I yield back.
Are there any other members who wish to be heard on the amendment? Are there any amendments to the amendment? If not, the question is now on the amendment offered by the gentleman from Maryland. All those in favor signify by saying aye.
Aye.
And those opposed say no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to. A roll call vote is requested. As previously announced, further proceedings on the question will be postponed. Members are advised that we anticipate that vote to be at roughly noon.
Mr. Chairman, could I have a roll call vote, therefore, having heard now from the ranking member on my amendment for health, for imminent to be struck, so that only health and safety would remain.
Point of order, Mr. Chairman. I think the gentlewoman withdrew her amendment.
The amendment that was offered previously was withdrawn, and I actually think we do can come to a resolution on that. I think gentlewoman made a good point about using the word emergency, which I think everybody understands, and I will work with her to.
All right, Mr. Chairman, if we can work together on the word emergency, then I would understand what you're saying. Thank you.
I thank the gentlewoman. So, as previously announced, further proceedings on the question will be postponed, which means we need to go to the next bill. We can't close out, obviously, that bill until we have that recorded vote. So the next item for consideration is H.R. 4361, the Federal Information Systems Safeguard Act of 2016. Clerk will designate the bill.
H.R. 4361 to amend Section 3554 of Title 44 United States Code to provide for enhanced security of federal information systems and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Hearing no objections, so ordered. I understand that the gentleman from Alabama, Mr. Palmer, will offer an amendment in the nature of the substitute to the bill. Without objection, we will call up the amendment in the nature of the substitute and then recognize Mr. Palmer to give one statement on both the ANS and the underlying bill. Without objection, that's the way we'll go, and the clerk will designate the amendment.
Amendment in the nature of a substitute to H.R. 4361 offered by Mr. Palmer. Strike all after the enacting clause and insert the following section, one short title.
I recognize Mr. Palmer for 5 minutes to explain the legislation and his amendment in the nature of a substitute.
Thank you, Mr. Chairman. The federal government's most important responsibility is the protection of this nation and our citizens against all threats and attacks, including our nation's information systems. As everyone on this committee knows, the breach of federal information systems at the Office of Personnel Management was one of the worst in our history, exposing the personally identifiable information of over 21 million federal employees, retirees, and family members, and compromising highly sensitive background investigation information and fingerprint data of the employees with national security clearances. The national security implications of the OPM breach will be long-lasting. Following the breach, OPM informed their employees that they could no longer use the OPM federal network to access Facebook, Gmail, and other sites in an effort to tighten defenses against future cyber attacks. This effort to improve security for OPM information systems was hindered by union representatives who claimed access to personal webmail and Facebook were benefits and argued that OPM could not take this action without first providing the union an opportunity to bargain. The union cited a 2014 ruling by the Federal Labor Relations Authority striking down an identical effort by Immigration and Customs Enforcement to strengthen their cyber security by denying their employees access to personal accounts using the federal network. Essentially, in a 2-to-1 vote, the FLRA said the imprecise wording in the Federal Information Security Management Act regarding agencies' IT security responsibilities failed to demonstrate congressional intent to vest the agency with sole and exclusive discretion over information security matters. The FLRA dissenting member wrote, "I cannot conclude that Congress intended for our statute to be read so expansively as to impose additional, in this case bargaining, requirements on federal agencies before they can act to secure the integrity of their federal IT systems, the breach of which could directly impact our nation's security and economic prosperity." H.R. 4361, the Federal Information Systems Safeguards Act, amends FISMA and makes clear the congressional intent that the head of a federal agency has sole and exclusive authority to take appropriate and timely action to secure their IT networks. The bill will enhance agencies' ability to protect federal agencies against cyber attacks and protect critical information databases as well as personally identifiable information of federal employees who trust their information will be safeguarded. In view of the breaches we have already experienced and the constant assaults against our government information systems, including breaches related to third-party sites, the need for giving federal agencies the authority and flexibility to secure their IT systems should be obvious. It should also be obvious that to deny them this authority is to put America's information systems and our federal employees at greater risk. The directors of federal agencies have a responsibility to protect their IT systems, and they should be able to carry out that responsibility without unnecessary interference or hindrance. This legislation is an important step we can take to empower federal agencies to quickly take appropriate action to secure their IT networks, to protect our information systems, and our employees from cyber attacks. I want to thank Chairman Chavitz for his interest in this issue, and particularly for co-authoring with me an article, How Collective Bargaining Undermines Cybersecurity, which appeared in the February 24th edition of the Washington Times. And if I may, Mr. Chairman, I'd like to enter this article into the record.
Without objection, so ordered.
I would also like to thank the committee staff for their assistance. Finally, I'd like to thank my colleagues on this committee who also serve on the Homeland Security Committee, Mr. Hurd, Mr. Walker, Mr. Carter, for suggesting language to clarify that this bill does not modify the Cybersecurity Act of 2015 and the Omnibus Appropriations Act of 2016. The only change to H.R. 4361, as introduced in this clarifying language regarding the Cybersecurity Act of 2015. Mr. Chairman, I urge my colleagues to support these bills. This bill. I yield back.
Gentleman yields back. Now recognize the ranking member, Mr. Cummings, for 5 minutes.
Mr. Chairman, I strongly oppose this legislation. As written, this legislation would give agency heads the authority to take, quote, any action, end of quote, they deem necessary to reduce or eliminate risks or weaknesses in information technology or information systems. Let me repeat that. Any action. That language is dangerously overbroad. To say that this language could be subject to abuse is a gross understatement. This bill could open the door to an agency violating other laws in the name of security. Could any action include ignoring directives from the Department of Homeland Security or cybersecurity? Could any action mean violating the Privacy Act? Could any action include overriding contracting requirements, the Federal Records Act, or transparency laws such as the Freedom of Information Act and the Data Act? Could any action mean an agency can avoid required reports to Congress on cybersecurity? Could any action be withholding information from an agency's Inspector General? The preeminent open government organization, opengovernment.org, opposes this legislation because it is, quote, open to great abuse, end of quote. The committee should not pass this language. I understand that this legislation may be intended to clarify that agency heads can block web-based email on agency computers without following requirements to bargain with the local union over the impact and implementation of such a change. There is no question that we need to protect our Federal IT information systems from cyber threats. I strongly support that goal. But no matter what you believe about blocking employee access to email, this bill goes so far beyond that it loses the point. We need to investigate the impact of this bill before rushing to enact it. The committee has not even held a hearing to understand the impact that this overly broad bill might have on security, human rights, privacy, contracting, or transparency protections. The amendment in the nature of a substitute says that the bill does not affect the cybersecurity provisions of the 2016 Consolidated Appropriations Act. But in technical assistance the Department of Homeland Security provided to our staff, DHS raised concerns that even with the amendment, this bill could conflict with authorities over cybersecurity given to OMB and DHS. And why are we exempting this one law when questions exist about the bill's impact in many critical areas? We can protect the Federal computer systems without unnecessarily broad and reckless language included in the bill. And so I hope that we can work together to, in the future, to develop language that is carefully crafted towards fulfilling that goal. And I'd like to enter into the record a letter dated February 29th from the NTEU, the National Treasury Employees Union, on this subject, Mr. Chairman.
Without objection, so ordered.
And I'd also like to enter into the record a letter dated January 11, 2016, from the American Federation of Government Employees on this subject, Mr. Chairman.
Without objection, so ordered.
With that, I yield back.
Gentleman yields back. Does any other member wish to be heard on this amendment in the nature of the substitute? Gentleman from California, Mr. Liu, is recognized for 5 minutes.
Thank you, Mr. Chair. With the repeated and massive cybersecurity breaches in our federal government, from OPM to IRS to recently the Department of Justice. I do believe we need a culture change, and we need to change how our federal government approaches cybersecurity. I believe agency heads should be given more authority, and if they don't execute properly, they should be relieved of their duty. But the ranking member makes some excellent points as to how this legislation could be interpreted. So I have a few questions, Representative Palmer, if I could ask them. How would you respond to whether this bill's language of any action could include violating the Privacy Act or overriding contracting requirements?
I would remind members that it is practice in the Congress to address, to not address a specific individual. Issues can be brought to the chair, but to address a specific member on a specific question is not the purpose of these comments.
Can I ask that of the chair?
You can ask it rhetorically. I would hope that we would have a response, yes. If you have questions about the bill.
Yes, I have questions about the bill.
Yes. Please proceed.
So should I raise the questions and then? Let me raise the questions. How is that? I'm going to ask the question.
Yes, raise the question.
So one question is, could any action mean to violate federal procurement regulations or Privacy Act? Also, could the term any action be read as, violating required reporting to Congress? And then my third question is, the way the bill is constructed, because it only exempts one law to which it does not violate, a court could interpret that as, well, Congress just meant to exempt that one law, and everything else, because this is a subsequent law, could potentially violate. So I'm interested in knowing the answers to those questions.
Would the chairman yield?
Mr. Liu can yield to you, yes.
Yes, I'll yield. Thank you.
Thank you, Mr. Liu. This bill applies to FSMA, and it simply assures that agencies can respond to cyber attacks, which have to be responded to in real time. It does not impact privacy at all. It is, and it does, and as the substitute bill indicates, does not compromise the authority of the Homeland Security as indicated in the Cybersecurity Act of 2015. So.
Mr. Liu reclaims his time.
Okay. So I'm going to ask another question to the committee as a whole. The way this bill is constructed, because it does talk about just the one law that it exempts, would this committee or the author consider putting in language along the effect that it would not be meant to override existing federal laws in other areas such as privacy and procurement and so on, or report language to that effect? And with that, I yield back.
Prior to yielding back, would Mr. Palmer like him to yield time to you?
I'll do that.
If the gentleman would yield. I think we can work out technical issues and report language. I think we can work those things out. I yield back.
Thank you.
The gentleman from California yields back. Does any other member wish to be heard on the amendment in the nature of the substitute? Are there any amendments to the amendment in the nature of a substitute? If none, the question is now on the amendment in the nature of a substitute offered by the gentleman from Alabama, Mr. Palmer. All those in favor signify by saying aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it. The amendment is agreed to. The question is now on the adoption and favorably reporting H.R. 4361 as amended to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it. A roll call is requested. As previously announced, further proceedings on H.R. 4361 will be postponed. We're still anticipating that we will have a recorded vote at roughly noon. In the interest of time, we're going to move the following bills under unanimous consent agreement. We have been chatting on both sides of the aisle. We have consulted with the minority and agreed to move these bipartisan bills expeditiously. I do believe there will be one set of comments, and we will recognize the gentlewoman from the Virgin Islands. But I'd ask, and Mr. Cartwright as well, but I do ask unanimous consent that the committee favorably report the following bills to the House. H.R. 2615, the Virgin Islands of the United States Centennial Commission Act, as amended by an amendment in the nature of a substitute offered by the gentlelady from the Virgin Islands, Ms. Plaskett. H.R. 2908, the National Bison Legacy Act, as amended by an amendment in the nature of a substitute offered by the gentlelady from Wyoming, Ms. Lummis. Senate Bill 1109, the Truth in Settlements Act of 2015, and the following postal naming bills, H.R. 3866, H.R. 4372, H.R. 4605. Does any member wish to speak on these bills? The gentlewoman from the Virgin Islands, Ms. Plaskett, is now recognized for 5 minutes.
Thank you so much, Mr. Chairman, and the ranking member. The month of March is really a significant month for the United States Virgin Islands. It's the month that we celebrate the contribution of outstanding Virgin Islanders, and it's also the month marking the anniversary of our islands formally becoming a part of the United States. This month is not only Virgin Islands History Month, but this marks the 99th anniversary of the transfer of the Virgin Islands from the Kingdom of Denmark to the United States of America. Nearly a century ago, the United States purchased the Virgin Islands from Denmark for its geopolitical importance. Prior to this purchase, the Virgin Islands had served as a hub of the Western Hemisphere commerce in the region for several centuries and served as a crucial role in naval military activities in the Caribbean basin. On March 31st, 2017, the Virgin Islands of the United States will celebrate 100 years as a possession and part of the Union of the United States of America. This bill establishes the Virgin Islands of the United States Centennial Commission to research, plan, develop, and carry out national activities the Commission considers appropriate to commemorate the 100th anniversary of the Virgin Islands of the United States becoming an unincorporated territory. This Congressional Commission will provide an opportunity to revisit the history leading up to and directly following the transfer of the islands from Denmark to the United States, and educate those unaware of that history on a national level of the importance of the territories to the geopolitical advancement of this great nation. It's imperative to the continued growth of this nation that it embrace and recognize the culture, history, and accomplishments of its many members. Recognizing 100 years of inclusion through a discrete, short-term, bipartisan commission comprised of House and Senate members, along with administration, other officials, and volunteers seems only fitting to mark that 100th year. In addition to planning commemorative events, I believe that this Congressional Commission will engage other lawmakers in Congress and elsewhere in a new national discussion about the challenges and the enormous opportunities present in the Virgin Islands. This coming centennial anniversary of the inclusion of the Virgin Islands allows us to revisit this history and our ongoing relationship. It's an opportunity also for us to highlight the enormous contributions to the United States these small islands of the Virgin Islands have made to this country, and the richness of our own heritage. Through political, military service, intellectual discourse, the Virgin Islands of the United States has and continues to contribute to the rich fabric of the United States while cherishing our unique Caribbean history and culture. Individuals such as the first African-American bandmaster of the U.S. Navy, Alton Adams, television producer and director Kelsey Grammer, Impressionist founder Camille Pissarro, as well as our great Tim Duncan, Virgin Islanders have contributed to the arts. Virgin Islanders have served as drafters, soldiers, and patrons to the new nation even before we are part of it, such as through Alexander Hamilton and David Levi Hewley, the first Jewish member of the U.S. Senate. The Virgin Islands were leaders on both sides of the great question of slavery and race in the new nation. Virgin Islander Denmark Vesey led one of the earliest slave revolts, while Judah Benjamin served as the Secretary of Treasury of the Confederate States during the Civil War. As explorers, intellects, the small islands of the Virgin Islands have contributed enormously to this country. We would ask, however, that this commission really highlight not just these things, but the continued wealth and importance that the Virgin Islands can have in the United States. As we enter our next century under the U.S. jurisdiction, the continued relevance of the region and its technology, economic leadership, and sophistication is something we are hoping to have discussed. Mr. Chairman, it is befitting that legislation is passed to form a Congressional Centennial Commission. And I want to take this time to thank you and your staff who've worked with us a tremendous amount on this bill over this last year. And we have arrived at a place, I believe, where both sides have found common ground. And I'm asking for your support, Mr. Chairman, in moving this out of committee and onto the House floor. I thank you so very much for your support and for your assistance in this matter, and I yield back.
I thank the gentlewoman, and I would strongly encourage members on their own personal dime to go to the Virgin Islands and personally celebrate its rich history. So,
Mr. Chairman, everyone in the committee is invited, particularly next year during our centennial. There will be lots of activities that I hope we can all host you and have a great time. You know, we are also known as the largest rum distillery in the Western Hemisphere, so it will be a good time for everyone. Not that that's the only reason to visit us, of course.
for the record, I will not be participating in the rum distillery, but I would very much like to explore the beaches. We'll keep going by talking to something. Let's now recognize a gentlewoman from Wyoming, Ms. Lummis, for 5 minutes.
Thank you, Mr. Chairman. I simply want to thank Representative Clay, Representative Noem, and you, Mr. Chairman, for working with me on the National Bison Legacy Act amendments. It's been great to work with you all, and I yield back.
Thank the gentlewoman. We'll now recognize the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Chairman Chaffetz, for holding this markup and including the bipartisan, bicameral Truth in Settlements Act. Every year, federal agencies sign hundreds of out-of-court settlement agreements with companies accused of breaking the law. These settlement agreements amount to billions of dollars annually paid by companies to resolve allegations ranging from environmental neglect to bogus contracting and consumer fraud. Some of the largest governmental settlements in the past few years address mortgage fraud, the sale of faulty and unsafe cars, and billions of dollars worth of Medicare scams. Republicans and Democrats don't often see eye to eye about the proper role and powers of the federal government, but I'm here to say both parties in both the House and the Senate agree that when it comes to enabling public scrutiny of executive agencies, more transparency is better. If the public cannot consistently access even the most basic information about these settlements signed on our own behalf, how can Americans know whether or not these agreements are any good or beneficial? Are they effective in deterring misbehavior? Do they unfairly punish companies? We need the facts even to begin figuring out the answer to these questions. That's why this Truth in Settlements Act is so critical. This legislation would set basic groundwork for real transparency in the deals signed by government agencies to settle the allegations of corporate wrongdoing. Secrecy and shadows should not be the default for these deals. The Truth in Settlements Act would require all agencies publicly to post their deals unless legitimate reasons are given to keep settlements confidential. It would also require agencies to be clearer about the true value of these deals. In just the past few years, we've seen federal agencies sign several large settlements with companies like Citibank or Hyundai, settlements worth several tens of billions in total dollars. The Bank of America deal in August of 2014 was touted as the biggest Wall Street settlement yet. Though the legal documents detailing the settlement were available online, the DOJ did not explain that the bank was actually paying only a fraction of the $16.65 billion amount announced in the press. The biggest part of the settlement value was credits granted to the bank for writing off bad mortgages and other practices the bank might have done regardless of that settlement. Likewise, the Justice Department failed to explain that the bank would be allowed to treat large portions of the payments as a tax deduction. And because of that, the deal appears to have been worth much less than the publicly announced amount. It was worth about $6 billion to the public rather than $16.65 billion. Executive agencies can be more transparent without hindering their effectiveness. A few agencies, like the SEC, already disclose much of the basic information about the settlements they sign. This should be standard practice for all agencies. The Truth in Settlements Act represents a significant bipartisan effort. Senators Warren and Lankford, ex of our own committee here, introduced Senate Bill 1109, which included a substantive amendment by Senator Vitter when passed unanimously by the Senate. And I myself was proud to introduce the House version, the companion legislation, H.R. 2648, with Representative Bill Posey on the House side. I'm glad to have been part of this strong bipartisan effort, and I'd like to take this opportunity to thank all of the offices involved for their hard work in getting to the bill to this point. I believe more transparency in executive agencies and more public scrutiny of the deals the government strikes are important reforms that we can all join together to support. I thank you again, Chairman Chaffetz, and I yield back the balance of my time.
I thank the gentleman, and I want to thank his good work. Mr. Cartwright, you have pursued this passionately, along with Mr. Posey, and that good hard work, I think, will pay off today and in the future, as well as our own Senator Lankford, who served previously on this committee, as well as Senator Warren. This is a good bipartisan bill. I'm glad it's included in this mix. Do any other members wish to speak on any of these bills that are under unanimous consent request? Oh, the gentleman from Vermont, Mr. Welch, is recognized.
Well, I just want to add my congratulations to the sponsors of this legislation. This really is a big deal. There's been an enormous amount of corporate malfeasance, and that gets exhibited in the fact that companies have been prosecuted, and then they enter into agreements where they pay billions of dollars. But the bottom line here is, what are they actually really paying? And when these settlements have a lot of fine print that none of us see, we don't know. And among other things, the fact that corporations or anyone, you know, it's not about a corporation, it's about a wrongdoer, and it could be an individual, it could be a corporation. But who ever heard of taxpayers picking up part of the tab? So you announce a $10 billion settlement, and that gets to be a deduction. And we wonder why the people we represent are fairly cynical and angry. And we agree on this. So here's the deal. If you're paying a settlement, you pay it, not the taxpayers, because you're entering into the agreement because you're admitting you did something wrong. And oftentimes, it's criminal behavior, but since it's a corporation, nobody goes to jail, even though lives have been shattered, health has been compromised as a result of the underlying misconduct. And the bottom line here, Mr. Cartwright, as you know, and Mr. Posey, we can't have the taxpayers picking up the tab for misconduct by corporations or individuals. And this is going to help us get some more control over that. And I thank the chairman and the ranking member for your cooperation on this.
I thank the gentleman. Does any other member wish to speak on these bills under consideration? If not, without objection, H.R. 2615, H.R. 2908, Senate Bill 1109, H.R. 3866, H.R. 4372, and H.R. 4605 are favorably reported to the House. As previously announced, we had some recorded votes requested. So the question is now on the amendment to H.R. 4612 as previously postponed. The vote will occur on the Cummings amendment to H.R. 4612. The clerk will call the roll.
Mr. Chaffetz?
No.
Mr. Chaffetz votes no. Mr. Mica? No. Mr. Mica votes no. Mr. Turner? Mr. Duncan? Mr. Jordan? Mr. Jordan votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Amash? No. Mr. Amash votes no. Mr. Gosar? No. Mr. Gosar votes no. Mr. Desjarlais? Mr. Desjarlais votes no. Mr. Gowdy? Mr. Farenthold? Mrs. Lummis? Mrs. Lummis votes no. Mr. Massey? Mr. Massey votes no. Mr. Meadows? Mr. Meadows votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Mulvaney? Mr. Buck? Mr. Buck votes no. Mr. Walker? Mr. Walker votes no. Mr. Blum? Mr. Blum votes no. Mr. Heiss? Mr. Heiss votes no. Mr. Russell? Mr. Russell votes no. Mr. Carter? Mr. Carter votes no. Mr. Grothman? Mr. Grothman votes no. Mr. Hurd? Mr. Hurd votes no. Mr. Palmer? Mr. Palmer votes no. Mr. Cummings? Mr. Cummings votes yes. Mrs. Maloney? Mrs. Maloney votes yes. Ms. Norton? Mr. Clay? Mr. Clay votes yes. Mr. Lynch? Mr. Lynch votes yes. Mr. Cooper? Mr. Cooper votes yes. Mr. Connolly? Mr. Cartwright? Mr. Cartwright votes yes. Ms. Duckworth? Ms. Duckworth votes yes. Ms. Kelly? Ms. Kelly votes yes. Ms. Lawrence? Ms. Lawrence votes yes. Mr. Liu? Mr. Liu votes yes. Mrs. Watson-Coleman? Mrs. Watson-Coleman votes yes. Ms. Plaskett? Ms. Plaskett votes yes. Mr. Desaulniers? Mr. Desaulniers votes yes. Mr. Boyle? Mr. Boyle votes yes. Mr. Welch? Mr. Welch votes yes. Ms. Lujan Grisham? Ms. Lujan Grisham votes yes.
All members who wish to be recorded, been recorded. The clerk will report the tally.
On this vote, there are 16 yeas and 20 nays.
The noes have it. The amendment is not agreed to. The question is now on the adoption and favorably reporting H.R. 46122 to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no.
No.
In the opinion of the Chair, the ayes have it. A roll call vote has been requested. Clerk will call the roll.
Mr. Chaffetz?
Aye.
Mr. Chaffetz votes yes. Mr. Mica? Mr. Mica votes yes. Mr. Turner? Mr. Duncan? Mr. Jordan? Mr. Jordan votes yes. Mr. Wahlberg? Mr. Wahlberg votes yes. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Mr. Gosar votes yes. Mr. Desjarlais? Mr. Desjarlais votes yes. Mr. Gowdy? Mr. Farenthold? Mrs. Lummis? Mrs. Lummis votes yes. Mr. Massey? Mr. Massey votes yes. Mr. Meadows? Mr. Meadows votes yes. Mr. DeSantis? Mr. DeSantis votes yes. Mr. Mulvaney? Mr. Buck? Mr. Buck votes yes. Mr. Walker? Mr. Walker votes yes. Mr. Blum? Mr. Blum votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Russell? Mr. Russell votes yes. Mr. Carter? Mr. Carter votes yes. Mr. Grothman? Mr. Grothman votes yes. Mr. Hurd? Mr. Hurd votes yes. Mr. Palmer? Mr. Palmer votes yes. Mr. Cummings? Mr. Cummings votes no. Mrs. Maloney? Mrs. Maloney votes no. Ms. Norton? Mr. Clay? Mr. Clay votes no. Mr. Lynch? Mr. Lynch votes no. Mr. Cooper? Mr. Cooper votes no. Mr. Connolly? Mr. Cartwright? Mr. Cartwright votes no. Ms. Duckworth? Ms. Duckworth votes no. Ms. Kelly? Ms. Kelly votes no. Ms. Lawrence? Ms. Lawrence votes no. Mr. Liu? Mr. Liu votes no. Ms. Watson-Coleman? Ms. Watson-Coleman votes no. Ms. Plaskett? Ms. Plaskett votes no. Mr. Desaulniers? Mr. Desaulniers votes no. Mr. Boyle? Mr. Boyle votes no. Mr. Welch? Mr. Welch votes no. Ms. Lujan Grisham? Ms. Lujan Grisham votes no.
How is Ms. Norton recorded?
Ms. Norton is not recorded. Ms. Norton votes no.
Does any other member wish to be recorded? Clerk will report the tally.
On this vote, there are 20 yeas and 17 nays.
The ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. The question is now on the vote on H.R. 4361 as previously postponed. The vote will occur on adopting and favorably reporting H.R. 4361 as amended to the House of Representatives. The clerk will call the roll.
Mr. Chaffetz?
Aye.
Mr. Chaffetz votes yes. Mr. Mica? Aye. Mr. Mica votes yes. Mr. Turner? Mr. Duncan? Mr. Jordan? Mr. Jordan votes yes. Mr. Wahlberg? Mr. Wahlberg votes yes. Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Yes. Mr. Gosar votes yes. Mr. Desjarlais? Yes. Mr. Desjarlais votes yes. Mr. Gowdy? Mr. Farenthold? Mrs. Lummis? Mrs. Lummis votes yes. Mr. Massey? Yes. Mr. Massey votes yes. Mr. Meadows? Mr. Meadows votes yes. Mr. DeSantis? Mr. DeSantis votes yes. Mr. Mulvaney? Mr. Buck? Mr. Buck votes yes. Mr. Walker? Mr. Walker votes yes. Mr. Blum? Mr. Blum votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Russell? Mr. Russell votes yes. Mr. Carter? Mr. Carter votes yes. Mr. Grothman? Mr. Grothman votes yes. Mr. Hurd? Mr. Hurd votes yes. Mr. Palmer? Mr. Palmer votes yes. Mr. Cummings? Mr. Cummings votes no. Mrs. Maloney? Mrs. Maloney votes no. Ms. Norton? Ms. Norton votes no. Mr. Clay? Mr. Clay votes no. Mr. Lynch? Mr. Lynch votes no. Mr. Cooper? Mr. Cooper votes no. Mr. Connolly? Mr. Cartwright? Mr. Cartwright votes no. Ms. Duckworth? Ms. Duckworth votes no. Ms. Kelly? Ms. Kelly votes no. Ms. Lawrence?
No.
Ms. Lawrence votes no. Mr. Liu?
Yes.
Mr. Liu votes yes. Mrs. Watson-Coleman?
No.
Mrs. Watson-Coleman votes no. Ms. Plaskett? No. Ms. Plaskett votes no. Mr. Desaulniers? Mr. Desaulniers votes no. Mr. Boyle? Mr. Boyle votes no. Mr. Welch? Mr. Welch votes no. Ms. Lujan Grisham? Ms. Lujan Grisham votes no.
Have all members been recorded? Clerk will report the tally.
On this vote, there are 21 yeas and 16 nays.
The ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. Without objection, pursuant to Clause 2L of House Rule 11, members will have 2 days to submit views on the bills considered today. I ask unanimous consent that the staff be allowed to make necessary technical and conforming changes to the bills reported today, subject to the approval of the minority. Hearing no objection, so ordered. There's no further business. Without objection, the committee stands adjourned, and I thank everybody for your participation today. We stand adjourned.